Dear learners, we are today going to discuss in this lecture the significant provisions of the ICSCR. In our previous class, we had already discussed the background under which the ICSCR was adopted. We also discussed that why the ICSCR uh, has weak implementation mechanism in comparison to ICCPR, and why the progressive realization of these rights under ICSCR have been aimed at when it was being drafted and when it was finally adopted. And we also found that the ICSCR has been ratified by a large number of countries, although it needs a lot of resources to realize the rights that have been that have been proclaimed under this ICSCR. We also discussed about the preamble, and then we found that the preamble of the ICSCR is citing, first of all, UN Charter, then Universal Declaration of Human Rights, and it also emphasizes the point that all rights are interdependent. So now, after having those those things discussed, we are going to discuss the significant provisions. So the first of all, after preamble, you will find part one, and in the part one, or article one. Article 1, all people have the right of self determination. That is being emphasized. Right of self determination, economic self determination is also important. It is not only the political dimension of the self determination, but economic and cultural self determination is also important. Within a country, for example, some communities may have that they want their cultural autonomy. So the cultural autonomy is to be also recognized. So all the people have the right of self determination. After that, we are, the part 2 that is discussing article 2 to 5. You will find article 2 says the states parties to the present covenant undertake to guarantee that the rights enunciated in the present covenant will be exercised without discrimination of any kind, such as to race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Important, So, the principle of non discrimination, we have been pointing out right from the very beginning that if you see the international instrument or the UN instruments of human rights, so the principle of non discrimination is the integral part of all the human rights treaties, covenants, and the declarations adopted by the United Nations, which is being re-emphasized here in this document also, that the principle of non-discrimination will be followed when these rights are being claimed. So there should not be any discrimination on the basis of race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. So equality and non-discrimination. Article 3. The state parties to the present covenant undertake to ensure the equal right of men and women to the enjoyment of all economic, social, and cultural rights set forth in the present covenant. You see that the equal right of men and women, again, equality is being emphasized. It also includes equal pay for equal wages as well. So, the equal rights of men and women, it means gender equality, gender justice that is being proclaimed. In the part third, you will find Article 6 to 15. What are the issues that have been taken up? Article 6, for example. The states parties to the present covenant recognize the right to work, which include the right of everyone to the opportunity to gain his living by work which he freely chooses or accepts, and will take appropriate steps to safeguard this right. So, first of all, you have freedom of choice so far as the profession or occupation is concerned. That is being emphasized. So, a particular kind of profession or particular kind of occupation cannot be imposed upon certain sections, which has been the practice in many countries. So what is being recognized here? That the state parties have to agree that the people will be having the freedom of choice so far as occupation, work, profession or trade is concerned. That is being emphasized. They have to freely choose. The state parties to the present covenant recognize the right of everyone to the enjoyment of just and favorable conditions of work, which ensure, in particular, you see, first of all, what is there? The just and favorable conditions of work. This term just and favorable conditions of work itself is quite wide and broad. It can include that, the work that the people are doing, they should not work in such a way which is going to affect their health, etc. So, but it has been already pointed out here that first of all, what do we mean by just and favorable conditions of work under this particular covenant? Number one, remuneration which provides all workers as a minimum with fair wages and equal remuneration for work of equal value without distinction of any kind, in particular, women being granted conditions of work not inferior to those enjoyed by men with equal pay for equal work. So you see that the no inferiority should be, inferior treatment or inferiority should not be accorded to the women. That was the common practice. So that is why perfect equality of or complete equality of men and women. Not only that while providing the job opportunities, but also with the principle of equal pay for equal work that is to be accepted. A decent living for themselves and their families. The fair and just condition includes a decent living for themselves and their families. So it means that the wages should be paid in such a way that they are leading a decent living for themselves and their families. Safe and healthy working conditions. Again, that is important. This covenant can be read with several other, laws or several other treaties of the United Nations, for example, ILO guidelines, ILO's convention, etc. So you'll find safe and healthy working condition must be there. So if the working conditions are such, for example, you'll find glass factories, for example, brass factories, for example, or the bangles industry that we have in our own country. There you'll find that, something that is being heating up, that is something that is being melting or melted on 1400 degrees centigrade. And there, the people are working. Sometimes children are also working. So that is why it means, that you must have safeguards for the people. And the safety measures must be adopted. So a safe and healthy working condition must be ensured by the state or by the people, those who are having those kind of industry. So, that has been accepted, and, it should not be such where the people are going or the people are prone to fatal diseases or the other kind of health issues they are going to encounter. It also includes equal opportunity for everyone to be promoted in his employment to an appropriate higher level, subject to no considerations other than those of seniority and competence. So there should be only one criteria, that seniority and competence can be taken into account, but other things cannot be taken into account while giving promotions. So it is not only right to work, but you'll find it is not only providing opportunity where the principle of non-discrimination and equality will be exercised or adopted, but also in the promotions. So there cannot be any discrimination on the grounds like race, color, sex, place of birth. Of course, competence and seniority can be taken into account, and they are taken into account all over for giving promotion. Again, important, the D, rest, leisure, and reasonable limitation of working hours and periodic holidays with pay as well as remuneration for public holidays. This is again important. This was demanded under the socialist movements, because if, for example, somebody say, if the Sunday is a holiday, why should the worker be paid? on for the work that they are not doing. But what is being recognized, that it is the inherent and inalienable rights of all working men and women, that they must have, first of all, rest, leisure, and reasonable limitation of working hours, means not beyond 8 hours the person should be forced to work, and periodic holidays as well. So, in our system, for example, in the government employees, they have CL, casual leave, medical leave, you'll find detention leave, earn leave, all these kind of things are there. At the same time, holidays are there, vacations are there. So, all these are being emphasized under, this ICSCR. Then we have Article 8, the right of everyone to form trade unions and join the trade union of his choice, subject only to the rules of the organization concerned, for the promotion and protection of his economic and social interest. You see that what happens, that the workers, they are mostly people who are dependent upon the work that they are going to do, and their livelihood, that is the source of their livelihood, and that is why they have only one thing to sell in the market, and that is their labor. So that is why when they are going to sell their labor, what happens, that the people, those who are having the means of production in their hands, either they are owning industry or any kind of offices, etc., so they are in a position to exploit the dependencies of the workers and the laborers. So, since the dependencies of the workers and the laborers can be, that can be exploited by the factory owners or those who are controlling the means of production, so that is why they must have some kind of mechanism, means workers and the laborers, so that they can fight for their rights. If for example, if the just and favorable conditions of work are not there, so they have to raise their voice. For that, they must have their own trade unions. Earlier what was there, that the protest of the workers was criminalized. It was not allowed. If the people were going for the protest, they were fired from the job. So, but now it cannot be done. Why? Because it has been recognized that they must have a right to join trade unions of their choice. The trade unions, different kind of professionals, they have their different kind of trade unions, and these trade unions, they lobby, they go for advocacy of the rights of the workers. So that is why, or the people, those who are in any kind of profession, not only workers. So that is why it is being recognized. Article 9, the state parties to the present covenant recognize the right of everyone to social security, including social insurance. The social security, social insurance, for example, you will find that if a person is in a job for 30 years and he is going to retire, so the pensionary benefits, for example, retirement benefits, for example, or the medical facilities that they are going to get. So the social security includes all these things, and it also includes social insurance, that they, after completing a job of 30 years, they don't get bankrupt. They are old people most of the time. The people, when they are going to retire, most of the people are not in a position to work now at the old age. So that is why social security is must under those kind of circumstances. So it has been also accepted. You can see how important this ICSCR is and how important its provisions are. Article 10, Clause 1, the widest possible protection and assistance should be accorded to the family. You see, family is being recognized as an institution and as the basic unit of society. So, the widest possible protection and assistance should be accorded to the family, which is the natural and fundamental group unit of society, you see, particularly for its establishment, and while it is responsible for the care and education of dependent children. Marriage must be entered into with the free consent of the intending spouses. You see, the free consent of the intending spouses, that is important. It means it cannot be forced, it cannot be imposed, and the freedom of choice is being emphasized here. At the same time, family is being recognized as the basic unit of society, and it is also being ensured through this article that the children of the employees or the people, those who are having their children, they should also get some kind of benefit. So different organization, they give, the tuition allowance for the teacher, or the employees, and they take care of the uh, children also. For example, if the healthcare facilities are there, and if any kind of a scheme is there for providing healthcare facilities, then the minor, the children are also included in it. Of course, when they become major, some countries or some organization may recognize, but most of the organization, they recognize that if the healthcare facilities are there, they are for the children or the family members as well. Article 10 clause 2, a special protection should be accorded to mothers during a reasonable period before and after childbirth. During such period, working mothers should be accorded paid leave or leave with adequate social security benefits. Important, very important. You see, during the pregnancy, for example, the women should not lose their job, because ultimately, the pregnancy is there, so that is why they cannot work. So that is why the maternity leave should be given to them. At the same time, if they are not working, it doesn't mean that they will not be paid. They should be given what is called paid leave. That is the right of every woman. If she is pregnant, then she will be getting maternity leave, and after that you will find child care leave is also given, or the so all these things are, and they are paid leave. It doesn't mean that that their payment will be curtailed because they are not working, because they cannot work. So this has been also recognized, of course, a very revolutionary kind of right, I will say, which is protecting the rights of women. Article 10, Clause 3. A special measures of protection and assistance should be taken on behalf of all children and young persons without any discrimination for reasons of parentage or other conditions. Children and young persons should be protected from economic and social exploitation. Their employment in work harmful to their morals or health or dangerous to life or likely to hamper their normal development should be punishable by law. A state should also set age limits below which the paid employment of child labor should be prohibited and punishable by law. You see, child labor is being criminalized. So, when for example, if a child of 10 years is there and if he is working, and that too in the hazardous industry or factory, that is a punishable crime. So, what is being, the protection of children is being ensured, and it is the responsibility of the state to criminalize such kind of work which is going to affect the mental health and other kind of problem it is going to create for the children. So that is being that is being applied here. Article 11, right to the standard of living for himself and his family, including adequate food, clothing, and housing, and to the continuous improvement of living conditions. So, everybody, whether a male or female, a right to the standard of living for himself or herself and his or her family, including adequate food, clothing, and housing, and to the continuous improvement of living conditions. That is again a right ensured here. The Article 12, the state parties to the present covenant recognize the right of everyone to the enjoyment of the highest attainable standard of physical and mental health. It is the mental health is also being emphasized. It is not only the physical health, mental health also. So if the living conditions are such, or the society is having such kind of environment where the mental health is also being affected, means psychological tormentation, if that is there, so that is also bad. So physical and mental health, that is being recognized. Article 13 recognizes one of the most basic social and economic rights or cultural right, that is right to education. It can be there in all the gamut. So it is very important. Right to education is being recognized. Right to take part in cultural life. So the communities or the groups or the individuals, they have a right to take part in cultural life. Then part 4 you will find Article 16 to 25, and part 4 of the ICESCR deal with reporting and implementation mechanism. for the economic, social, and cultural rights outlined in the covenant. So, that is dealing with the implementation mechanism that is there. We will discuss, after winding up this particular part. So, and part fifth is dealing with, the dealing with the final provisions related to the covenant's entry into force, amendments, and miscellaneous details, etc. Now, when we are going to discuss the implementation mechanism, before that, we have to see, what is the monitoring body created under the ICSCR. The monitoring body of the ICSCR is the Committee on Economic, Social, and Cultural Rights, which is a body of human rights experts tasked with monitoring the implementation of the covenant. This monitoring body, that is Committee on Economic, Social, and Cultural Rights, consists of 18 independent human rights experts elected for 4 years terms, with half the members elected every 2 years. The committee oversees implementation of the International Covenant on Economic, Social, and Cultural Rights through its consideration of reports. That is the compulsory, procedure of implementation. So, through reports, individual complaints, of course, are optional, interstate complaints, of course, optional, and inquiry request, and its preparation of general comments, substantive statements, open letters, and general discussion days. General discussion that take place. The optional protocol of the ICSCR was adopted by the United Nations General Assembly on 10 December 2008 and came into force on 5th May 2013. Earlier we will find that it had only the reporting procedure, but what has happened after this, the optional protocol, earlier it was not there. Originally it was not there with the ICSCR. So this optional protocol, which was adopted in 2008, it establishes mechanism for bringing violations of economic, social, and cultural rights before the UN Committee on Economic, Social, and Cultural Rights. Specifically, what is there in this optional protocol? An individual complaints mechanism, that is called individual petition system, where individual can, after exhausting all local remedies, approach this committee, and it can bring into the notice of the committee the violation of the rights that are there in the ICSCR. Then an interstate complaint mechanism, it is also established. Of course, it has not been accepted by most of the states. And an inquiry procedure. If there is violation, then the inquiry can be initiated by the committee. There are 46 signatories and 29 parties to it. Optional protocol, you can understand why such, a small number of states have recognized this. Now we are going to discuss the implementation mechanism under ICSCR. While the ICSCR itself tasked dedicated complaint mechanism, the optional protocol to the ICSCR fills this gap by introducing three key implementation tools. Of course, we have already discussed the individual complaints mechanism. So, individual under the jurisdiction of a state party that has ratified the optional protocol can submit complaints alleging violations of their economic, social, and cultural rights directly to the Committee on Economic, Social, and Cultural Rights. This we have already discussed. Then this allows the individual to bypass domestic remedies if they have been exhausted or deemed ineffective. Significant, of course. Complaints must be based on economic, social, and cultural rights, means the violations of economic, social, and cultural rights are to be established, not the civil and political rights, means all the rights or the provisions that are there in the ICSCR, if they are violated, or any of the provisions, any of the rights that are granted by the ICSCR, then only the individuals can approach the committee. So, complaints must be based on economic, social, and cultural rights violations and meet a specific admissibility criteria set by the optional protocol and the committee, on the and the Committee on Economic, Social, and Cultural Rights. If found admissible, the committee investigates and examines the complaint, issuing views, its own opinion and views, observations, and recommendations to the state party for appropriate action. Then we have interstate complaint mechanism, created through optional protocol. All state parties to the optional protocol to lodge complaints against the state parties alleging violations of economic, social, and cultural rights obligations. This mechanism encourages the states to hold each other accountable for upholding economic, social, and cultural rights. Of course, a quite radical kind of implementation mechanism, not acceptable to most of the states of the world. Complaints must be based on violations within the jurisdiction of the state parties being complained against. Or needless to say, and it is obvious that the complaint must be based on the violation of the rights mentioned in the ICSCR. Similar to individual complaints, the you know Committee on Economic, Social, and Cultural Rights examines the complaint and issues views, that is, views, observations, or the opinion and recommendations to the concerned state parties. Another important is inquiry procedure. It empowers the Committee on Economic, Social, and Cultural Rights to initiate inquiries into situations of alleged economic and social and cultural rights violation in a specific state parties with their consent. That inquiry can be also initiated, but the consent of the state is must. So it means it becomes very difficult. For example, if there is an allegation against the state that the state will never want, then an independent and impartial inquiry, that too by a supranational body, should be there. So that is why this is there, but it is hard to implement. This allows the Committee on Economic, Social, and Cultural Rights to proactively investigate potential issues beyond individual complaints. Inquiries can involve visiting the territory of the state party with its consent, gathering information, and issuing reports with recommendations. Now we are going to conclude our discussion on this International Covenant on Economic, Social, and Cultural Rights. So the first of all, in conclusion, we have to understand that the International Covenant on Economic, Social, and Cultural Rights is a vital human rights treaty that recognizes and protects a wide range of economic, social, and cultural rights that you already noticed. It includes different dimensions of economic, social, and cultural rights. For example, it is including child labor, just and favorable working conditions, equal pay for equal wages, the maternity leave during the pregnancy, or child care leave, etc. All these are coming under it. So that way, you can see that wide range of economic, social, and cultural rights are covered by this covenant. These rights are essential for ensuring a dignified and fulfilling life for all individuals. You can understand that, especially economic rights and social rights and the cultural rights, they are vital for ensuring a dignified life. Hungry, homeless, naked, jobless person cannot lead a dignified life. So that is why, it can be understood with the dignity of individual. So if these rights are implemented, and then a dignified life is possible. Without the recognition of these rights, dignified existence of individuals will not be possible. So that is why this is again important to notice. The International Covenant on Economic, Social, and Cultural Rights has been ratified by 171 states parties, making it one of the most widely ratified human rights treaties in the world that we have already discussed. So you see that if you see the gamut of rights that is there in this economic, social, and cultural rights covenant, you will find it is wide. But even then, 171 state parties have are there to this covenant. which is of course very significant because it means in principle all these 117 countries have agreed that these economic, social, and cultural rights are important, essential for all the human beings for their dignified existence and for their well-being. So with this, we are moving to another important point of conclusion, that is the Committee on Economic, Social, and Cultural Rights reviews reports submitted by state parties, considers individual complaints if there is any, and conducts inquiries into alleged violations of the covenant. Of course, very few countries have accepted, but I think this is something that should be accepted. And the human rights organizations and the human rights activists, they are working upon it. Why? Because you'll find these days a lot of countries are violating the rights of the migrants, diaspora, or you'll find sometimes native people are also being threatened, indigenous people, the people who have been living in a particular ecosystem for centuries. Now they are being displaced and they are becoming what we call the victims of development. They are called victims of development. So it means if a particular region is developed and the people from those areas where they have been living for centuries are being displaced, that is not only uprooting them from their area, but it is also, just denying their dignified existence. The optional protocol to the ICSCR, which has been ratified by 29 state parties, we can say 29 state parties have only, ratified, establishes additional mechanism for enforcing economic, social, and cultural rights, and that we have already noticed, that is it, individual complaint mechanism and interstate complaint mechanism, and of course the inquiry procedure. So, despite the weakness and limitations, the International Covenant on Economic, Social, and Cultural Rights has made a significant contribution to the advancement of economic, social, and cultural rights around the world. There is no doubt in it. So, the 171 parties are there. It means, in principle, they have already agreed upon these rights. So, whether they are able to provide it or not, or whether they have a political will to provide it or not, that is a very different matter. But at least in principle, they have all agreed upon this set of rights, that they should be available to all the people. That itself is a significant contribution. However, what we must realize, that continued efforts are needed to strengthen implementation mechanism, hold state parties accountable, and ensure that everyone can enjoy their economic, social, and cultural rights. Why this point is important? These days, you will find, because of economic disparity that we are seeing in different societies, because of those economic disparities, you will find social tension and the social conflict is developing. So this social tension and social conflict, if that is developing because of the economic disparities or because of the denial of the rights that we are talking about, the economic, social, and cultural rights, that is never a good sign for any society. So this is the reason that we all know this, that peace and prosperity go together. So the progress of a nation, development of a nation, it all depends upon peace, and that peace will be disturbed if these rights are not implemented in letter and spirit. So that is why I think, in the light of the economic, social, and cultural rights, at least we get a parameter, we get a yardstick to judge the performance of a state on the basis of these rights, whether the country is able to ensure the enjoyment of these rights or not. Thank you very much.